And we are live.
Okay. Good morning. It's Friday, April 1st. And this is a meeting of the Sexual Harassment Prevention Panel. And we are here to start revising the current policy that's been in effect. It was voted on in 2018. And we have here Representative Lindley, Representative McCoy, Representative Maricki, Representative Feltus, and Council Jen. Sorry. Sorry. And Arlene Duncan. And we have the chair of the Senate panel, Senator Hardy. So I think we're all set to go. And I think, Jen, if you want to start us, and we're looking at the document posted on the committee, the Sexual Harassment Prevention Panel web page. And it's under documents and handouts under the name of Damian Leonard. So which one are we going to look at first?
So, all right, good morning. Jennifer Kirby from the Office of Legislative Counsel. We will be looking at the policy. So I think I'm going to look at your documents, but one of them is policy and one is procedure.
Okay, so we're going to look at policy. Okay.
Look at policy.
All right.
And I will put the I will put the document up on the screen as well. All right, so there we go. So this is a proposed draft for discussion, and this would be specific potentially to the House because there are some references in here to the House and to the Speaker, and then it also references that there are similar panels for the Senate and the joint panel. Damian Leonard from my office has been working on this with Arlene. Damian is working in another committee this morning, so I'm going to go over the language with you. That's why it's posted under his name. So this would start out by saying that it is the policy of the Vermont, in this case, House of Representatives. So these are the changes that in highlight and with underline and strike through in some places it are the changes. So this would say it is the policy of the House as opposed to saying of the General Assembly, although it would be the same policy, hopefully, to provide a professional working environment free from sexual harassment, and that the House prohibits both sexual harassment and retaliation for reporting sexual harassment or cooperating in an investigation of sexual harassment. I'm just letting Katie McLinn in. She is a colleague from the Office of Legislative Counsel who works with this committee. So then it talks about the House having established the Prevention of Sexual Harassment panel pursuant to House Rule 90C, and then taking out the reference to the Senate having a similar panel that would go in the Senate's policy. And that here's the reference that in addition, a similar panel exists in the Senate and a joint panel composed of members of the House and Senate panels has jurisdiction over staff from legislative offices that are not specifically dedicated to either chamber. So under your policy, the House Clerk's office and the Speaker's staff would all be subject to this policy. And feel free to stop me as we go through if you have questions or comments about anything we're looking at. Then it says that the panels investigate and adjudicate complaints in a manner that is fair, expeditious, and nonpartisan. And this policy has been adopted by both the Senate and House panels and all staff offices, assuming that is ultimately the case. But it takes out the reference to it serving as a joint policy. So I might just flag that. Some of these things don't stand out to me until I read them out loud. I'm not sure it makes sense specifically to say that this policy has been adopted by, for example, the Senate, since it will be a slightly different policy specific to the Senate. So, yeah.
So we're adopting a policy, and the staff offices have to adopt the policy as well.
And that's the language that's used in here. And Arlene, I don't know if that's something that you had discussed with Damian.
Yeah, we didn't. I know that we discussed the joint, the joint
I'm not quite sure because they're employed by.
I know the office of, well, sort of. The office, I know the Office of Legislative Counsel had adopted the prior policy. I'm not sure quite what that will look like for all staff offices, so I think it's just something, it's another good thing to flag.
Yeah.
Um,
Yeah, good catch, yeah.
Yeah, I don't recall the previous. I think it may have been in the previous one. I don't have that one with me, but we can look.
Okay.
So then that was my question specific to staff offices. Good questions. The next paragraph says that this policy sets standards concerning and regulates the conduct of representatives, and it takes out the reference to senators and all staff who work for the House. And this is where that term regulated individuals that we used in the current policy comes in. And it specifies that the policy is intended to protect legislators, staff, legislative pages and interns, and members of the public, including lobbyists, advocates, and members of the press who experience sexual harassment attributable to regulated individuals. And then it just moves this idea of the jurisdiction of the panels. Some of that is not necessary if we have these separate House and Senate panels. So that is, I think that provision comes out, at least from the policy. It may end up in the procedure. Then it has, yeah.
I have a question. Is it all right? It says attributable to regulated individuals. What if it goes the other way? Is that later in the policy, like a lobbyist or advocate?
So this is really about
staff or
the
something.
people over whom the General Assembly has authority.
Okay,
You don't have authority over
yeah,
lobbyists or members of the public, other than, ability for Sergeant at Arms to exclude them if they are behaving really outrageously. So that's not addressed in here. We would need to deal with a situation like that differently, depending on what was going on, maybe contact that person's employer,
okay.
or try to address that in another way.
Yeah, we had a lot of discussion about this last time around, about how that would be dealt with.
Thanks.
Sure, and that really comes up because when you get to the recommendations that the panel can make, they're really over things that have to do with members of in this case, members of the House.
Right, okay.
Then we have the definition and examples of sexual harassment. This is very similar to what's in our existing policies. Talks about sexual harassment as a form of discrimination based on sex, sexual orientation, or gender identity. Says that sexual harassment in the workplace is illegal, and all employers have an obligation to ensure a workplace free of sexual harassment. Sexual harassment means unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature when, and then these are really the first two instances, just some language changes, cleanup changes. Submission to the conduct is made either explicitly or implicitly a term or condition of employment, or submission to or rejection of the conduct by an individual is used as a component of the basis for employment decisions affecting the individual, or number three, the conduct has purpose or effect of unreasonably interfering with an individual's work. This is taking out performance. It doesn't just have to be their performance. It's really the impact it has on their work environment, or of creating an intimidating, hostile, or offensive working environment. I don't know if there's anything you want to add on any of this, so feel free to jump in there. Specifies that sexual harassment may be verbal, physical, auditory, and this would add written, or visual, or a combination thereof. It may be, yeah.
Well, I wondered if it was important to true this up with the sentence prior to the 1, 2, and 3. Just because that sentence says an other verbal or physical contact, and I'm just not sure we're articulating verbal or physical.
Yeah, no, that's a great point, that there's a lot more forms
Or
in that
you could
second.
just request for sexual favors, period, given of a sexual nature, and then
Maybe we
define
take out
it.
the verbal or physical in that
Yeah.
case, so it says, and other conduct of a sexual.
Electronic.
Yes, there is electronic, and that was something that our committee looked at related to.
Could be written, but it could be visual.
Right, well, the visual is in that second,
Yeah.
after the 1, 2, and 3, but I think Representative Bloomley makes a good point about having some consistency.
So I think if you stop it there, because then we go down to explain it afterwards.
Right, so we could say, and other, what if we just said, and other conduct without saying verbal or physical conduct? And then we can get into the forms right afterward. Thank you, that's a great point. And do you want to specify electronic, even if it may be inherent in some of these other ones? Or do you think the visual and written?
You know, and I said it's written, but sometimes it may be a photo.
It might, yeah.
Right.
That would be visual.
That would be visual,
Electronic.
I think, but if you
There are
were,
so many different ways, like there's Twitter, I mean, there might be other, I don't know, I think it should be specified, but I don't know how they're.
all right, well, let me make a note and,
You might describe electronic as the means of doing it. I mean, whether either directly or electronically.
Right.
All of those things.
uh-huh. Yeah, I'm thinking through how that is,
Physical, auditory.
if that might be a way to do. I made a note about electronic and
Sit on that.
By whatever
think
means
about that.
are available.
Right, and maybe communicated by any means or something like that.
Right, because it could be
That's good.
directly between persons, or it can be electronic form or a written form, a letter. It can be.
Okay. Great. All right, so picking up after word combination thereof, it may be subtle or overt. Sexual harassment refers not only to conduct that is unwelcome, but also to conduct that may be personally offensive or that fails to respect the rights of others, lowers morale, interferes with work, and this would take out the word effectiveness, or violates a person's sense of well-being. Persons of all genders and gender identities may be the victims and perpetrators of sexual harassment, and sexual harassment may occur in instances where the parties are or are perceived to be of the same or different genders or gender identities. Sexual harassment may occur in situations in which one person has authority or the appearance of authority over another. Harassment may also occur between persons who are equal in terms of authority or the appearance of authority, or between a person who has less or appears to have less authority and another person who has or appears to have greater authority. And I think this is particularly relevant in the legislative context where there are kind of differing levels or appearances of authority.
Are you the upper chamber or the lower chamber? I'm kidding.
Sorry. And I welcome you if you have input on any of these to pop in as well.
Great, thank you.
Examples of sexual harassment include the following when we're just looking to clean up some of this such to the, it's just more straightforward. When the acts or conduct falls within the above definitions. So examples include, and I think these are from the states, or the Department of Labor's policy too, either explicitly or implicitly conditioning any term of employment. It gives as examples continued employment, wages, evaluation, advancement, assigned duties or shifts on the provision of sexual favors, touching or grabbing a sexual part of a person's body, touching or grabbing any part of a person's body after that person has indicated or it is known that the physical conduct is unwelcome. And I think we talked about it in the past on this one, I don't see it in here, but known or should have known.
Yeah, we
that it would be.
hassled a lot over
Yeah,
that last time.
you do have that language also. If you look down a few bullets down, you do
Right.
use that language, so maybe it would be consistent to put it there.
Does that make sense to folks? I know there's been concern about how somebody should know or what would be the criteria. But I think there may be some that are fairly objective. I'll make a note, and if Damien had a strong reason, we can come back to it. Continuing to ask a person to socialize on or off duty when that person has indicated a lack of interest. Displaying or transmitting sexually suggestive pictures, objects, cartoons, posters, or other visual matter if it is known or should be known that the conduct is unwelcome. Continuing to write sexually suggestive notes, letters, emails, text messages, or other communications, or continuing to verbally engage in a sexually suggestive manner, looks like that's a new addition, if it is known or should be known that the person does not welcome the conduct. Referring to or calling a person a sexualized name, if it is known or should be known that the person does not welcome the conduct. Regularly telling sexual jokes or using sexually vulgar or explicit language in the presence of a person, if it is known or should be known that the person does not welcome the conduct. Retaliation of any kind for having filed or supported a complaint of sexual harassment or having participated in an investigation of alleged sexual harassment. I think that's a new addition. And it gives as examples, ostracizing the person, pressuring the person to drop or not support the complaint, or adversely altering that person's duties or work environment. Derogatory or provocative remarks about or relating to a person's actual or perceived sex, sexual orientation, or gender identity. Harassing acts or conduct directed against a person based on, a little language change, the person's actual or perceived sex, sexual orientation, or gender identity. And finally, off-duty conduct that falls within the above definitions and affects the legislative work environment.
So I just have one thing. We start off with examples of sexual harassment include. Should we say include but are not limited to, or some kind of like, you can go beyond these, you know what I mean?
Yeah, in our
I know there's
statutes,
examples, but
in our statutes, we actually have, because we had the same disagreement for years and years, a definition that says includes means including but not limited to. So I struggle with putting it in anywhere, but I agree this is not statutory. So we can certainly,
I just don't want the panel to kind of like, wow, it doesn't fall.
You're right.
your counsel will tell you including is not an exclusive or exhaustive
Yeah.
term, but,
I don't know how you want to word it, but.
yep, let's look at it.
I think that's
So-
You can whole ledge council.
No.
I have a comment back up halfway down the
Oh, sure.
list. We have continuing to write sexually suggestive notes. I don't think we need the continuing. I think just plain writing sexually suggestive notes.
Because you have that, if it is known or should be known that the person is
Right.
not welcome.
Right.
I think that makes sense. Is that feel comfortable to others?
I mean, we have continuing up above, but that's because you've asked someone out and they've said no.
Right.
And so you,
Yeah.
but this other one, I think we don't need the continuing,
Great.
just plain
Writing.
just plain writing.
Yeah, if you got a sexually suggestive note, that would not
I
be
would think so.
Right, you don't want to have to wait for the second time.
Right.
To say, you should have done this. Okay. Anything else on the list of non-exhaustive examples?
I just have a question, like off-duty conduct. I remember we talked about that last time. So that could be something that happened across the street at the Capitol Plaza, right?
Right, if it affects the legislative work environment.
Where somebody came up to a regulated individual, was inappropriate with someone.
Anyone, right?
Yeah, I mean, it could be a lobbyist.
Yes, if it affects the legislative work environment, so it would make it difficult or
A regulated
unregulated.
individual. is-
Yep.
Okay.
Exactly. All right, so our next section is on reporting and responding to sexual harassment. And it says that persons who believe that a regulated individual has sexually harassed them or who have witnessed behavior by a regulated individual that they believe is a violation of this policy. So we talked about this in the past, and I think we put it in your kind of updated proposed policy, but this idea of a witness being able to report as well. So they have a range of options for resolution under the policy, and then it specifies that a person may identify objectionable conduct. The person has the right to identify objectionable conduct to the individual who engaged in that conduct and ask that individual to stop. However, a person is not required or expected to do so, and there is no requirement or expectation that a person will identify objectionable conduct to the regulated individual before pursuing other options for resolution. They can contact the appropriate panel. Person may contact any member of the panel with jurisdiction over a regulated individual that they believe may have engaged in sexual harassment. Any person may request that the panel attempt to resolve the issue informally. A person who believes that a regulated individual has sexually harassed them or retaliated against them may also file a formal complaint with the panel. And we go into more of these in the procedures. Each panel has a legal obligation to ensure that the General Assembly is a professional working environment free from sexual harassment, and to take immediate and appropriate action to ensure that conduct that violates this policy does not continue. And you'll see this theme in the next couple of sections as well.
I just say, this may be really picky and I'm not even, so is it a professional work environment or a professional working environment?
I don't have a strong-
May not.
You have a preference? I'm not sure.
Well, the phrase that I often read is professional work environment.
Well, then let's make that change.
It's also interesting that in light of what we passed yesterday, to be able to meet remotely, the phrase working or a work environment free from sexual harassment and to take immediate and appropriate action.
Right.
So,
I think that dovetails with the resolution that the
Yeah.
changes that you passed.
and then there was some discussion for the panel. I should let people know that we had discussion in the Rules Committee about whether it needed to say that a person could ask for, had the right to ask for an in-person meeting. And there was a lot of discussion about that. What if we have a public health emergency, et cetera, et cetera? We wouldn't want to feel that somebody had to appear. So the House Rules Committee decided to leave it for now because there was an amendment that I was going to put forth about that, and to discuss it in the context of all the different, the anti-discrimination panel, the ethics panel, and the sexual harassment panel. So that may be coming, that we sort of try to figure out how to write that, because one person on the Rules Committee was concerned that if you have the ability to meet remotely, that you just wouldn't, you wouldn't get together at all, and that person might feel that they needed a face-to-face. So just for context.
Yeah, and I think the further under that,
Oh, yeah,
that's
you were
the
there.
end, afterwards. And she said it would probably come as a House resolution, which would come through House rules and not each individual panel.
Yeah.
That's what she was thinking that would happen.
But would it would amend the House rules?
Yes.
Okay,
For
that makes
all
sense,
three of
sure,
them.
that you could do all three
But
at
I don't,
once.
yeah, that's what she was kind of
So I
thinking
think the
yesterday
Rules Committee is going to be meeting
Yes.
to discuss this
Yeah.
further.
before adjournment.
Yeah.
Because that's what that specifically says. During adjournment, we.
Oh.
Yeah.
Right.
Which means that when we're in session, we will meet in person. But during adjournment.
Will
would have-
I'm sorry, will this amendment to these policies happen? I'm just concerned about matching up our policies, so I'm thinking about the timing.
I can send you, I'll send you the language that we,
Or perhaps the Secretary of the Senate and the Clerk of the House can
Get together and figure it out.
Yeah.
Right, there was a change made to the rules that established this panel and that set out in general terms the policy to allow them to meet remotely when the legislature is not in session. So you may want to look at something similar for the Senate, but I think it doesn't hinge on when you finish making the changes in the policy.
Oh, I see, it's just, okay. Yeah, I think we have one for all committees at this point until a certain date.
I can send you the language.
Yeah, okay, that'd be great.
It was the amendment to a resolution regarding Rule 90C.
It was on yesterday's calendar.
Question. In practice, then, if somebody contacts the panel, does the full panel need to meet if somebody is out of town? How does that work? Is there a certain number that's
It's still a
required?
quorum requirement, I think is what we have.
Okay,
So if there were three of us, yeah.
Our requirement of the committee able to meet.
Go ahead.
Okay, so that was contacting the appropriate panel, and we have contact a supervisor. So the person may contact the person's supervisor regarding any conduct that the person believes may be a violation of this policy. regardless of whether the individual engaging in that conduct is a regulated individual. And all supervisors have a legal obligation to provide a professional, here we go, with the work environment, free from sexual harassment, and to take immediate and appropriate action to ensure that sexually harassing conduct does not continue. And I'm just flagging this for myself that we may want to couch this a little bit more in the sense that they can contact their supervisor and the legislative staff. It's sort of a very broad, I mean, they can contact their supervisor, but we're not telling others what to do. And then they can also contact the Office of Legislative Human Resources regarding any conduct that they believe may be a violation of this policy, regardless, again, of whether the individual engaging in that conduct is a regulated individual. And similarly, the Office of Legislative Human Resources has a legal obligation to ensure that the General Assembly is a professional work environment free from sexual harassment, and to take immediate and appropriate action to ensure that sexually harassing conduct does not continue. In addition to those options, a person may pursue other avenues outside this policy as set forth in the final section, and that's the one that talks about some of the other state and federal options. A person may choose to pursue or not pursue one or more of these options. For example, and then this is just moving, we'd already talked about not having an obligation, requirement or expectation to talk to the regulated individual. That was above. So for example, an individual is not required to contact a panel member informally before filing a written complaint. So there's no kind of hierarchy or step process required. And then we have the exception that exists in our existing policy as well. There is an exception when any regulated individual witnesses or is made aware of sexual harassment committed against any person who is or appears to be under 18 years of age. And under these circumstances, the regulated individual must immediately inform the chief of the Capitol Police Department and the sergeant at arms of the sexual harassment. Finally, in this section, members of the panel, legislative supervisors, and the Office of Legislative Human Resources shall keep confidential any information reported to them pursuant to this policy, and any information obtained during an investigation carried out pursuant to this policy, except to the extent necessary to carry out an investigation to enforce the provisions of this policy and to ensure that sexually harassing conduct does not continue.
Jen?
Yeah.
Just to go back to the last paragraph, are we mandated reporters as House members?
I don't believe so under your under the mandated reporter statute, but you are under this.
Okay.
All right. So then we have contact information. So this would provide email information for all 5 members of the panel, and also some contact information for House supervisors and for the Office of Legislative Human Resources. Then it talks about potential penalties for engaging in sexual harassment. If this panel finds that there is clear and convincing evidence, so that's in the standard we've used in the past, embedded in here, that a violation of this policy occurred, the panel shall impose or recommend corrective action as follows. If the regulated individual is a representative, corrective action may include counseling or training, removal from a committee or committee leadership, censure, or expulsion from the House. The panel will impose or recommend corrective action pursuant to applicable policies and the House rules. If the regulated individual is the House clerk, corrective action may include counseling or training, censure, or removal. The House panel, again, shall recommend appropriate corrective action to the House Rules Committee, and the Rules Committee would determine the appropriate action and may propose a resolution for House consideration imposing that action. If the regulated individual is an employee of the Speaker or the House Clerk, recommended corrective action may include counseling or training, reprimand, loss of pay or vacation days, demotion, or termination. And directs the House panel to meet with the Speaker or House Clerk as applicable and present its findings and recommendation for corrective action. And the Speaker or House Clerk as applicable would impose appropriate corrective action in consultation with the Office of Legislative Human Resources. And then it just gives a nod to the Senate and legislative staff that the policies for the Senate and legislative staff offices provide similar consequences for individuals who engage in conduct that violates those policies.
I just ask a quick question about the very first, the panel shall impose or recommend corrective action pursuant to, and I'm just wondering, how does the panel decide whether it is recommending or it is imposing?
With what's within your authority is really where that dividing line would be. So the panel could, the panel could pursue counseling or training, but you could not remove someone from a committee. That's only something only the speaker could do, or you couldn't expel someone.
Okay, all right, thank you.
Well, to that point, in the other policy, maybe we're going to get to it in that other document, there was a whole couple of pages about the process by which, you would have a hearing, leading up to a hearing, the process, if you file a formal complaint, there are all these different steps.
Yeah.
It could wind up in a hearing, could, with different.
That's all in the procedures.
Yeah.
Right.
Still there, just in a different.
Okay.
Okay.
Yes, so you're not jumping from, you received a complaint to what are we recommending?
That's
as
right.
far as-
That's right.
Cool, and now Damien has joined us. Okay, so potential penalties.
Katie left, right?
Yes, I think Katie had to go to committee. So rotating staffing here. Morning, Damien.
Good morning.
You're up to page 5 of 6. Do you want to take over or do you want me to keep going?
Why don't you keep going since I'm I'm just getting caught up.
No problem. Okay, so the next language here talks about interns, staff, and volunteers who work for a representative. And most of this is consistent with your existing policy, but just tailored to the House. So any representative who employs an intern or staff person or accepts services of a volunteer to do legislative work must provide the sergeant at arms with a name, address, and contact information for that person. And if the intern, staff person, or volunteer is a minor, the representative must also provide the name, address, and contact information for the parent or parents or guardian or guardians, and provide additional information as the sergeant at arms requires. Directs the sergeant at arms to provide every intern, staff person, or volunteer with a copy of this policy, and the contact information is already in it, and shall ensure that the person understands how to report sexual harassment. If the intern, staff person, or volunteer is a minor, the sergeant at arms must also provide a copy of the policy to the minor's parent or guardian. And then it requires the sergeant at arms to provide the name, address, and contact information of all interns, staff persons, and volunteers, and the contact information for their parent or parents, if guardian or guardians, if applicable, to the speaker. We get to training and information. So this directs, and again, this is just tailored to the House, directs the speaker and the chair of the House panel to ensure that regulated individuals receive training on this policy, and that the training is open to members of the public, including lobbyists, advocates, and members of the press who may work in or be present in the State House, and that this policy must be posted on the General Assembly's website. And then you struck the language on additional training. I don't know if that was because of something else. Okay, I'm not sure. Then we have some other resources. So we get into a potential question for you here. This would authorize the panel to appoint up to 3 representatives to serve as sexual harassment prevention facilitators for the purpose of providing information about this policy to other members on a confidential basis without initiating either the informal or formal panel processes. This is modeled to some extent on a process we had in the Office of Legislative Counsel, with facilitators able to provide information to staff members without it triggering a reporting requirement or an obligation to pursue remediation actions.
I have a question about
Yeah.
that. So this would only be if somebody, this isn't about members going up to people and saying, I want to tell you about our policy. It's if you receive, somebody asks,
Right.
somebody reports something, or even has a question. Hey, I was wondering about this. I had this experience and I didn't know.
Right. I think it's exactly that one. This happened to me. I don't know if I want to do anything about it, but what are my options? And
And
then
then-
report it to you. It's sort of,
And then it would go to one of the facilitators to sort of take that a
it
little
would
bit.
be another option available.
Yeah,
to
So
membership.
people really approach the facilitators directly.
Not through
So-
Molly.
Right.
Yeah, exactly. I've served as one of these facilitators in our office. And so people would come to me or another facilitator and say, hey, this happened in committee today, and I'm not sure how I feel about it. Can we talk a little bit and, talk about my options? Sometimes that involves a little bit of coaching or support if the person wants to engage in the identifying the objectionable behavior step with that individual, or sometimes it's a conversation about, this is how you could, pursue this with a panel or with your supervisor or something like that. And so a lot of it is information, and then some sort of support for the sort of person-to-person contact that might happen before you go to the panel, when you just say, hey, that joke you made really made me uncomfortable. Could you not do that again? That sort of conversation. And so this is it really addresses sort of the lesser issues or instances where people are just not sure what to do, and they want to talk to someone that they're comfortable with and they trust, but they're afraid of like escalating things if it's not necessary. And they're just not sure if they want to go that next step with the panel. So it doesn't involve the panel at all, except to the point of kind of naming who the facilitators are.
And would the facilitator let other panel members know or no? No.
The
Okay.
facilitators, the way we've
Next
worked in our office is we keep it confidential among ourselves. And we only talk to the other facilitators if the person says, yeah, I'm comfortable with you talking to them. So Katie McGlynn, who was with you just a minute ago, is the other facilitator in our office. And so if someone comes to us, a lot of times what we'll say is, I'd like to discuss this issue with my colleague, Katie, before, I give you a full set of ideas here just to see if she has any other thoughts. Is that okay? And if they say yes, then I would reach out to Katie and we'd sit down, and then we might meet with the person again, the two of us, or I might just meet with them myself, or vice versa if the complaint comes to her. So it's really totally internal to the facilitators. And our job is really, we're not making a judgment on the behavior. We're not investigating. We're helping people sort of strategize about what their options are under the policy. And in some cases, we're helping kind of prepare them for, the conversation, which can be uncomfortable, where you identify something that you found objectionable, and ask the person not to do that again. And so that's really our role. And then if people are interested in filing a complaint, sometimes we'll help them figure out, who to contact, particularly because the current policy doesn't have contact information. So sometimes people forget who's on the panel. And so we'll talk to them about, you could talk to your supervisor, or these are the members of the House or the Senate panel as appropriate that you could talk to.
Okay, great. Thank you.
Yep.
Thank you.
So this is putting this idea of facilitators into the House policy. And so the second sentence says that a person may communicate confidentially with a facilitator at any time regarding the person's options for resolution under this policy. And so as Damien was saying, this is a conversation that doesn't mean anything has to go further. Once you contact a supervisor or the panel or human resources,
Good point.
somebody has to do something. There's that legal obligation to take immediate and appropriate action. If somebody just wants to talk through what happened to them or explore what their options are without triggering some additional action to occur, then a facilitator may be a place for them to go. So if you were to decide on having some facilitators, then we can provide their names and contact information in here as well. And then it says that a person who pursues any of the options for resolution under this policy does not give up the right to pursue other remedies provided by law. And this is in your existing policy as well. This policy is not intended to preclude a person from hiring a private attorney, pursuing legal remedies, or making a complaint to the EEOC, Vermont Human Rights Commission, the Attorney General's Office, or the State Ethics Commission.
I just have one possible addition, and that's the Vermont Women's Commission or Vermont Commission on Women. The reason being that these are government entities that can be really intimidating to people, you know, because it can feel like you are, you know, you're beginning a whole legal process and you're not even sure that that's what you want to do. The commission has been a place where folks could confide and say, you know, I'm not sure, I don't even know if this constitutes harassment. And it feels, they feel a little less exposed. It's just one of many resources. I just put that out there for consideration.
Could men make a complaint
Yeah.
or talk to the Commission on Women?
They could, the name of the commission might make people feel that it's not a place that they could go, but we're listing a range of places, so it seems
I
to
think
me.
that's a really good point.
The one
So-
thing that, sorry, David.
No, that's okay. I'm sorry. It's hard when you guys are in a tiny box. I'll wait till you're finished. Let me just put up my hand and I'll just wait to be called on.
Okay. The one thing I would say about that is these are all agencies that you can actually file a complaint and then they have to do an investigation and make a determination, I think. The Women's Commission is not. So they're kind of a resource.
Yeah.
They kind of like the facilitators
Yeah.
are to maybe talk about it and think about what your options are, how you feel about what happened, et cetera. But it's not as my understanding, these 4 places are places you can actually file a complaint, right, Jen?
I believe that's true. I think Damien is more familiar with some of them than I am.
Well, I think we could talk to the Women's Commission and see how if they see any role for the, you know, I think we can discuss it with Carrie to just see, well, how would that work, or could she be a resource and how? So I think we can have further discussion on this. Damien, you were gonna say something?
Yeah, I was going to say exactly what was just said. These are 4 entities where you can actually file a complaint. So if you do add something like the Women's Commission or another outside group that provides information on the law, and I would agree that the Women's Commission has a wonderful resource on their website. I've never had to contact them personally, but I know that their staff are exceptionally knowledgeable and very helpful. So if you did want to add that, I would just add it under a different section so that people don't get the idea that if they want to pursue a legal remedy, they can contact the Women's Commission, because that's not the Women's Commission's role. But if you wanted to add, you know, outside groups that can provide information on the law or something like that, that would certainly fit within the policy. Or it could be something that you keep on your webpage in a separate document, you know, resources or helpful links or things like that, if you wanted to do that as an alternative approach. But the one thing I would recommend is just don't mix the 2 lists, because the last thing I would want is someone to call the Women's Commission hoping to file a complaint and then be turned away because
Yeah.
the Women's Commission can't actually prosecute a complaint in the same way that, for example, the Human Rights Commission could.
Okay, well, we can
Noodle on a
discuss that, you know, when we have
sentence or
our next
something
meeting,
that
I think we can.
I just know that it's that having that, somebody may not be comfortable speaking to a representative either. A member of this committee, because it might be about a member, that it just may not feel safe. So it is a resource that is safe just to explore. Like, I don't know, is this harassment, and, should I go through the panel, or should I maybe file a complaint with the Human Rights Commission, or, so we can find another place maybe to reference
Yeah,
that.
I think we can discuss that. So I think maybe people have to go, you have to go.
You wanted, there is literally, we're at the last
Oh, right,
paragraph,
sorry,
bottom of the page. No, that's fine. And then
Forgot
we're
about that, right.
done with this document. So this specifies that each of these agencies may conduct impartial investigations, facilitate conciliation, or pursue litigation in state or federal court as appropriate. And that individuals are not required to file a complaint pursuant to this policy before contacting or filing a charge with one of these agencies, or before hiring an attorney to pursue a civil action in court.
So does anybody have any comments or questions before we adjourn?
Can I just ask another process question? I'm sorry, I'm hung up on this, but is it possible that you all would finalize this and then we could have the Senate panel look at it before anybody adopts it, so that you don't adopt it and then we look at it and find something that
Yeah.
the Senate really is opposed
Oh,
to?
yeah.
And
I think that's what we were trying to do.
is that, was that you were, okay.
Yeah.
Sorry, I just want to make sure that.
We're doing our policy. We don't care what you think.
Well,
Okay.
All right.
no,
chances
definitely.
are they're gonna be fine with
We
it, but I
definitely
don't
wanna
want to
be
speak
aligned.
for them.
We all want to be aligned with each other.
Thank you.
Okay.
Thank
So,
you.
Does anybody, Damien, did you have something else to add?
Nope, nothing else to add.
All right, so,
So I'll circle back with Damien and Katie and Mike, and we'll talk about the potential issues and potential changes.
so when we meet next, one of the things we need to do is talk about the facilitators, talk about, and then I guess at some point, and then we need to go over the procedures. Yeah.
Longer and denser.
Yeah, okay, so, Jen and Arlene, thank you so much for being here, and we will meet next week, next Friday, at the same time. I believe it's in this room, but we'll find out.
Okay. Yeah, we'll follow up with Mike.
Yeah, okay, great. All right, thank you, everybody, for your work.
Are we ready to go offline?
Pardon me?